Well, Vice President Joe Biden continues his talks with leaders on both sides of the gun control issue today. But what Biden alluded to yesterday is what has people talking. The possibility that President Obama might use an executive order to regulate firearms. Could it happen? This is a reality check you won't see anywhere else. Let's start by listening to what Vice President Biden said.
If the president is going to act, or executive orders, executive action that can be taken, we haven't decided what that is yet.
So is it possible that President Obama could attempt to create some gun laws via executive order? Well, yes, it's possible, but would that hold up in front of the Supreme Court? Maybe not. First, let's talk about what the executive order actually is. In many ways, presidential executive orders are similar to written orders or instructions issued by the president of a corporation to its department heads or directors. When a president signs an executive order, it becomes law 30 days after being published in the Federal Register. The executive order is not supposed to be a way, though, of bypassing the legislative branch. They are only supposed to give direction to departments of government over which the president has direct authority. While they do bypass the U.S. Congress, which of course is the standard legislative lawmaking process, no part of an executive order, and this is important, may direct the agencies to conduct illegal or unconstitutional activities. And that would be where this talk of an executive order on gun control could fall flat. Because the question would be, is the president attempting to issue an executive order on gun control violating Second Amendment rights? The reason this is such a big question is because if President Obama were to issue such an executive order, for instance, let's say banning so-called assault weapons or rifles with high-capacity magazines, that order would without question have to go before the Supreme Court. The court would then have to decide exactly what weapons do Americans have rights to. There are two Supreme Court cases that have dealt with this already. The most recent, though, was the case of District of Columbia versus Heller. The legal fight was over whether banning handguns in D.C. was a violation of the Second Amendment. The High Court ruled that handgun bans were a violation. Justice Scalia wrote the majority opinion in which he said this, quote, "The Second Amendment extends to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding." But Scalia left the door open just a little bit by saying a 1939 Supreme Court case, United States versus Miller, allows for limitations on the right to bear arms. Quote, "supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons," end quote. So what exactly does that mean? Well, after all, what weapon isn't dangerous? That's what makes it a weapon. On the other hand, unusual weapons constitute exactly what? RPGs or a tank? Well, maybe. But certainly the AR-15, for instance, more than 500,000 sold in the United States in just 2009, and you can buy them at Walmart. Calling that an unusual weapon would be a stretch. What that means for you is that if the administration does attempt to ban like this, it would be a long, very long fight in court. No ban would take place tomorrow. And arguments of banning certain guns over how scary certain rifles look, well, that may not prevail in front of the Supreme Court. And that is Reality Check. You can find the sources for this story posted on our website at fox19.com. If you'd like to make your voice heard on the story, head over to my Facebook page. You can find it by searching Ben Swann.